start, I think we've had some more of you join. So as I said, I'm Reagan Persaud. I specialise entirely in children law matters and in particular care proceedings. With me, I have Francesca Massarella, who is a pupil in Chambers and who has assisted me in preparing for this seminar. So she will also deliver a part of this for you. Now, I've circulated a handout, which is quite an extensive handout, and we're going to work from that to get an idea of where matters are at. If you haven't had a copy of this handout, don't worry too much, because I'll pop my email address in the chat. Just drop me an email, and after the seminar, I will email the handout to you. So let's make a start. This seminar today will cover, does the local authority have a duty to assess family members in cases which can lead to a placement order? Now, actually, if we look at the part about duty to assess family members, just to be clear, yes, we are going to address in cases that lead to a placement order, but we're going to deal with in cases that come up, even if they won't necessarily lead to placement orders, and the exploration of wider family members generally. I'm sure many of you have had this issue come up on cases where you think, oh, do we need to explore that particular channel? What if a parent objects to it? What do we do in that situation? And so that's what I'm going to try to deal with and address today. So we look at the learning objectives. We're going to cover the relevant law. We're going to cover the procedure if a parent objects. And what I mean by that is what you then have to do. But we're actually going to cover the actual procedure, which is the application you have to make on the ground if you're a solicitor and how you tackle it. And then I'm going to go through with you, or Francesca will go through with you, some examples of when this issue has arisen and how the court has responded to it. So if we turn to the law first of all, now just to let you know, this issue, as you can imagine, has come up since far back as I could see. It was around the 90s, wasn't it? Possibly the 80s that these issues were coming up. And they primarily came up in cases where the local authority had a newborn baby and the mother was wanting to relinquish care and wanted the child adopted, but didn't want wider family to know about the child's existence. And so parties had to deal with, how do we deal with that? Do we notify father? Do we notify grandmother? Do we notify auntie? And there was a balancing exercise between respecting the wishes of the mother on the one hand, maintaining the integrity of the adoption process, versus should these people have a right to know? What would be different if they did know? Potentially, could we have found a home in the family? And so there was lots of case law that's gone on for decades now on this particular issue. And I always think the best place to look at it is a judgment that Mr. Justice Cobb gave that we're going to look at, called Re H. But before we turn to that, let's start with where the local authority sits, because this seminar is primarily for local authority lawyers. The starting point for the local authority, and the reason why I can understand why all local authorities would be concerned, is because fundamentally the Children Act, the spirit of the Children Act, very much talks of children remaining in the family. And I've given you there section 17 and section 22 as examples about the local authority looking at family members, relatives, connected persons to find a home for children. And of course, if we link it back to adoption cases in particular, cases you will apply for a placement order, we have the situation that we all know we have to satisfy the nothing else will do test. That's a high limit to pass. And actually, does it mean that you have to explore all of the family, fully prove to the court that you've looked at those options? And I think that the spirit fundamentally is that you should be exploring all avenues. But of course, the nothing else will do test, as we know, is about realistic options as well. So you don't need to do full assessments of everyone. Viabilities, getting enough information to know that that person may not be viable is enough to cross that. And of course, we know, therefore, that there is that competition, isn't there, of interest between satisfying the nothing else will do and being able to satisfy the adoption and children checklist factor of the ability and willingness of the child's relatives to care for them, versus that respect for privacy, versus that how far do we go in terms of looking at whether there are family members or alternative carers that can care. And I would love to say to you, as a local authority, you have a duty to assess this wider family. The answer is you don't. And the case I mentioned in Re H very clearly sets out, as you'll see from the quote I've taken at paragraph 22, there are no provisions of the Children Act or the Adoption and Children Act which absolutely require or place a duty on a local authority to inform, consult, assess, or otherwise consider members of the wider family of a child in circumstances such as these. Now, pausing there, you might think, well, if we don't have a duty, how do we satisfy nothing else will do? And I have sympathy with local authorities and social workers and social care generally, who are looking at these options and looking at how are we going to make sure that we get a final plan that is ADM approved and actually that can be ratified by the court. And so there is that ongoing conflict between the two, but I think your fundamental has to be there is no duty to do it. The spirit of the Children Act, the spirit of the Adoption Children Checklist means that you should be exploring these options, but there is no duty. And where does that leave you? Well, it leaves you here. It means that if there is an objection from a parent, for instance, to certain family members being explored, then actually you don't have to explore them. I'll come back to that because there is a legal test to be applied as to what you do in those circumstances. If you look at ABC, and I always say ABC was a Court of Appeal decision on this matter in 2020. And along with Re-Age, it summarizes very well, it's very long judgments, but they summarize very well the history of case law in these matters, bringing it up to date. And ABC is where a set of criteria was set out as to what should be done in cases where the local authority feels, oh, we need to explore a particular family member or friend or connected person, and there is opposition from a parent to do so. But what ABC says here in terms of your obligation to assess, there is no statutory duty upon a local authority to make inquiries of every case, and the issue of notification is a matter of discretionary judgment in light of all the facts. Notification means notifying the family members, the father, the person you wish to explore. Re-Age, again, we come back to that, which was a case, a decision by Mr. Justice Cobb, which was later analysed, to be fair, in ABC as well, that says the courts have been keen to emphasise that if family members are identified as potential carers, it is not contemplated the local authority duty to consider them extends to a duty to uncover every stone, nor exhaustively examine the ground. And that is the point I was making. That's a quote from RIAR, which is one of the earlier cases. But the point being, there is A, there is no duty, and B, if you are going to explore family, you only need to go so far as exploring whether they are realistic options, which I'm sure many people know in terms of how we already deal with adoption cases on the ground. So where does that then leave us? Well, I'll tell you where that leaves us, and let's turn to the test. Where that leaves us is this, is I would say for local authorities, when you look at adoption cases, when you look at any case really that involves care proceedings, or that may involve a removal of the children from the primary carers, the parents, you should look at the wide family, but don't feel that there is a duty to do so if, say, someone objects to it. And what you actually need to do there is to apply the factors in ABC from 2020. So let's look at some relevant extracts from that. What that says there, and I've highlighted the parts in the extracts that I'm going to read out to you. Most of all, the notification decision has life-changing implications for the baby. It may influence whether adoption happens at all, and if it does, a sound adoption has its foundations in the integrity of the process. I think that makes sense to everyone, doesn't it? It's that really, if you explore the wider family, you might find someone. So there is a real seriousness if someone does object to what we do, and to do we explore them or go down that path. Some may have been, the law aims to distinguish between the fast track adoption cases, but in the end, each case is unique and the outcome is dependent on the facts. Some may have been a fleeting presence in the mother's life, so some of the family members, but others may be more significant figures who have been kept in the dark and would be astonished to find a baby had been born and adopted without their knowledge. So you can really see, just from reading this judgment, the competing factors and the different arguments on both sides as to how far the authority should go in exploring wider carers. And here we go on, and I'm not going to read every extract for you because you can see it there. But the fundamental, I will say, that we come down to from ABC is this, is that when we come to decide what we should do in that case, what the court will do is it will apply a certain test on the facts of the case, and every case is fact specific, and decide whether in fact certain family members should be explored, whether there should be wider family assessment. So if we look at what will logistically happen on the ground, the local authority may start planning for the family either upon the issue of proceedings or in the pre-proceedings process. And at that stage, you would normally, and it's quite right, and I would say you should continue to do it, look to explore the wider family. But if a parent says, no, I don't want this person to know, no, I don't want the father of the baby to know, no, I don't want the grandmother to know, no, I don't want these aunts to know, and you think actually we may need to explore that option, then you have to make an application to the court, either in the pre-proceeding stage or in the middle of live care proceedings, for the court to determine whether that family member, those friends, that father of the baby should be properly notified of the existence of the child, notified that we're in care proceedings, and notified that they could be assessed to care. And so that is what this issue really grapples with. And at that point, I say to you, yes, local authorities should explore wider family, but if someone objects, you don't have a duty to assess that person. You need to get to the bottom of why they've objected. What are their reasons for doing so? And if they still stand by their reasons after the end of that discussion, you as a local authority should bring an application to the court so that the court can determine the issue, applying the factors in A, B, and C. So what are those factors in A, B, and C? Well, what I want you to look at is what page is it, Francesca? In 4.5 into the handout, where we talk about the welfare of the child. And is welfare the paramount consideration? Interestingly here, when Mr. Justice Cobb made a decision on this matter in Re H, a year before the Court of Appeal looked at it in A, B, and C, he felt that the child's welfare was the paramount consideration. However, the Court of Appeal took a different approach a year later in ABC, and obviously the Court of Appeal is the law on this above Mr. Justice Cobb, with the greatest of respect to him. And they took the view that actually there was a lot to be said. That means that the child's welfare, when it comes to this decision of who is to be assessed as a wider carer, is not the paramount consideration. I will leave you to read that judgment for yourself, but the fundamental reasoning behind that is because this is a case management decision. It's a decision about who should be assessed prior to one deciding what's right for the child later on. And so the Court of Appeal took the decision, well, what's right for the child later on will be a welfare analysis, but the decision as to who to assess is not a welfare analysis kind of matter. And so the welfare checklist and the paramountcy of the child, it's not the leading factor. But the Court of Appeal did say that the welfare of the child, the issues of delay, they are still important factors to be considered. They're just not paramount. And so then no doubt you will all ask me, well, what is paramount, Reagan? What do we have to look at? That means that actually this is what we do when we bring this application to the court to say, mom's object and we need to assess the wider family. Well, what you do is covered on, let's just find the right page. There we go. So under the heading summary, and this is all quotes from the judgments of ABC because I've extracted a lot from it because it's a long judgment to try and help you with it. If we go to page 6, so paragraph 6, after summary, it says there is no single test for distinguishing between cases in which notification should and should not be given. But the case law shows that these factors will be relevant. Now, I will say to you, this is what you're applying. Every case will be decided on its own facts, but when you come to framing your submissions before the court and saying to the court, this is the test you apply, this is what you use to decide whether in fact we should assess certain wider family members.
My vision coming in with these cops.
Sorry guys, just give me 2 seconds. Yeah. Francesca's just going to ask Lee to mute. Oh, I think he's done it. Francesca's done it. She's gone. Well, we'll continue anyway. So this is the test that you need to apply when you will look at this. And really, let's go through that to understand. The first thing you look at is who has parental responsibility for a child. Because of course, if a father, for instance, if the mother goes, I don't want the father to know about the child's existence or to be assessed as a carer, the first thing you want to look at is, does he have PR? Because if he does have PR, he's instantly a party to proceedings. The second factor is the Article 8 rights, whether that of the wider family and of the child come into play. Because in fact, whether the father, married or unmarried, or a relative have an established or potential family life with the mother or the child, the right to a fair hearing is engaged and strong reasons are required before the withholding of information can be justified. So in these types of cases, and when you read the case law, I think you do get a flavour of this. is that there are relatives who are very distant, who may wish to care if they were told that a child existed, but actually has very little or have had very little to do with the mother or the father. And in those cases, the court may say, well, do they have a right to family life because of the distance, because of how remote they are in terms of their relationship and the likely relationship that they would have with this child? And so Article 8 rights are engaged, and I would urge you to familiarise yourself with that again, because they're very relevant. Some people will have Article 8 rights, like a father who, for instance, has been very committed to the mother, was committed during the pregnancy, but simply doesn't know that the child's now been born, doesn't know that we're in the middle of care proceedings. And actually, the track record shows that if he did know, he would wish to become involved and to play a role in that child's life. Now, he may have an Article 8 right. He may have a right to family life that's being interfered with, as opposed to your father who had a one-night stand, who mother's not heard from since, who has not bothered to check in at all, who may know on the side of that she may be pregnant and has not bothered to speak to her about that or to try to engage. Does that person have an Article 8 right? Well, given what we know of how they've behaved, it gives us an accurate reflection of what they are likely to behave or how they're likely to behave, and they may not have that right engaged. And again, it's for you to apply and argue on the facts of your case. The substance of the relationship, aside from the presence or absence of parental responsibility of family life, an assessment must be made of the substance of the relationship between the parents, the circumstances of conception, and the significance of relatives. The purpose is to ensure that those who are necessarily silent are given a notional voice, so as to identify the possible strengths and weaknesses of any argument they might make. Put another way, with what degree of objective justification might such a person complain if they later discover they have been excluded from the decision? The answer will differ as between a father with whom the mother had a fleeting encounter and one with whom she had a substantial relationship, and as between members of the extended family who are close to the parents and those who are more distant. So again, it's the factors, it's the kind of things I discussed when it came to the right to family life. It's how engaged would they be with this child? How engaged would they be in the circumstances had they known of the child's existence, of the fact that we're in care proceedings? That will be relevant for the court to consider. Now, Francesca will discuss with you a case later on than I did this earlier this year before Mr. Justice Cobb on this issue. And that factor was very important because, and it was the case of Re-F, because in that case, we had a mother who had been adopted, and when she then gave birth, she had introduced the child not only to her adopted family, but to the birth family. And the substance of the relationships was important because, and the right, and whether or not they had a right to family life was important, but it was important because the birth family, so her original blood family, had only had a fleeting relationship with the newborn infant and the mother, by virtue of the adoption and the physical separation that followed for many years. And so Mr. Justice Cobb did consider very carefully that whether they had a right to family life was very limited, and also the substance of the relationship between them and the child was very limited. And in the end, we had a decision that they should not be explored to consider whether anyone in that family could care for the child, even though one of the potential options on the table was that the child would need to be adopted, potentially, if the mother could not care, because the adopted family couldn't offer the child a home. The mother may not have been able to offer the child a home, and the only other option would have been potentially to explore in the birth family. And Mr. Justice Cobb decided against that. And the substance of the relationship and the Article 8 rights of that family played a big part in that decision-making process. The likelihood of family placement being a realistic alternative to adoption. Now that is important because actually we're not going to say, oh, assess the wider family if we think that the risks are already so high around the wider family that it's pointless. It's not about that, is it? It's about assessing the realistic options. And I always think that's really hard because if you can't notify them that there's a baby whom they may wish to care for, who may end up being the subject of a placement order, how much information can you actually gather about them to know if they could care or not? Because there are issues around, can you and should you really be gathering police information on these people? Should you be looking at their social care records? Should you actually be contacting other people to talk about them to get a feeling of their day-to-day life? And what the case law says is, when this type of issue comes up, one of the things that they need to do is get a statement from the person who objects. So for instance, it's normally the mother that says, I don't want X person being approached. And in that statement, A, she has to set out her objections, why she objects to that person being told. But B, she should set out what she knows about that person or that particular persons in terms of their background, so that the court can properly assess whether or not they're viable or may be viable. But also the case law says that that has to be taken with a pinch of salt, because of course the mother, the one objecting, and I say the mother because it's normally the mother has a vested interest making sure that these people aren't approached. So she may not give the full picture of what they would be able to offer, what their lives would be like, and whether in fact there could be a realistic option for the child. So the case law says, A, we should get the objector and the mother or the father or both to put in statements about what they know, so we get a sense of that. But B, social care should make inquiries insofar as they are able to, and the court accepts entirely that there are restrictions on that. But insofar that they're able to, put as much information as they can before the court as to why potentially these people may be viable. And again, in the case I had before Mr. Justice Cobb, we had a situation whereby we wanted to explore the birth family. And whilst there was some concern that actually, well, if the birth family couldn't care for the mother when she was a child, would they have been able to care for the newborn now? There were actually family members in that family who had their own children. So we had some aunts, some uncles who had had their own children. We had some cousins who were now adults like the mother, who had their own children and could now potentially care for a newborn baby. And so we didn't know the full details, but as social care, we knew that. We knew that there were people in that family who had very young children in their care, and that they were not involved with social care in their respective regions, which of course is relevant information for the court to know, because it would mean that potentially there could be someone realistic, a realistic option therein. So the court will look at that as one of the factors as well. Then we have to look at factor 5, which is the physical, psychological, or social impact on the mother or on others of notification being given. Now, pausing here, these factors are all listed, and like the welfare checklist, one could be given more weight than the other. They're all factors that will be relevant. But I think, in my practice and experience, this factor carries a lot of weight. Why does the person object, and what impact would it have on them if we decided against them? On the face of it, we know lots of parents who object for reasons that we sometimes think, well, I'm not sure that you can object validly on that. But of course, we have issues that come into place like, and it is the next factor, but I'm going to talk about it now, families who have certain religions, which mean that if there's a child out of wedlock, there may be consequences for that mother or for that father, whereby they may get disowned from the family. And those factors are the kind of things that have to be considered. They may be objecting because they know if the wider family are told, they may get disowned. And that is a relevant factor that needs to be analysed and considered by the court. What are the objections and what are the consequences of the objections? But you see, again, there are always two ways of looking at things, because you may also get the type of case whereby there is a very staunchly religious family who may disown, say, the father for having a child out of wedlock, and that's why he objects. But their religion and their culture may also mean there's no way they will let that child be adopted. They will find a way, find a family member who is realistic and viable to make sure that child stays in the family. And so the court will have to balance that. Father may get disowned, which is why he's objecting, on the other, because of the religious issues or the cultural issues. But on the other side, the religious or cultural issues may well be the answer for this child to remain in the family. And so, again, relevant factor for the court to consider. And it links in with the other one, cultural or religious factors. And it's exactly the same. So I won't cover it again because I used the same example about the impact on the parent or the objector. The availability and durability of the confidential information. Again, I've merged some of this in my discussions with you, but that comes down to the same things I said earlier about this local authority gathering as much information as it can without breaching confidentiality. The mother or the father or the objector or all of them putting as much information as they can in statements before the court. And then we have the issue of the impact of delay. Now, I raise that point because the general tone and tenor of the case law is that whenever this issue arises an application should be made quite promptly to have the issue determined. What we shouldn't allow is for that issue to go on until close to where the local authority is going to file its final evidence, for them to go, we've looked at everyone else, none of these people work, now should we look at these people? No. The second you know at the start of proceedings that a parent objects, make the application and get a determination, and that will then avoid delay later on. And that is the tenor of what this case law speaks about. And then finally, you've got factor 9, which is your catch-all, any other relevant matters. So the court can look at anything else that comes up on a case-by-case basis. But let me read the final paragraph to you. It has rightly been said that the maintenance of confidentiality is exceptional and highly exceptional where a father has parental responsibility or where there is family life under Article 8. However, exceptionality is not in itself a test or a shortcut. Rather, it is a reflection of the fact that the profound significance of adoption for the child and considerations of fairness to others means that the balance will often fall in favour of notification. But the decision on whether confidentiality should be maintained can only be made by striking a fair balance between the factors that are present in the individual case. Now, the reason that paragraph comes in is because there were discussions, and it's quite obvious reading the judgments that there were discussions around should not notifying, should an order saying you shouldn't notify certain family members be the exception rather than the norm. And the case law doesn't actually say much about it should be exceptional, but the tenor of it, as here in that paragraph, is very much along the lines of in most cases we will decide to notify. But of course, there will be cases where you don't. And again, it has to be on a fact-specific basis, like the one I had earlier this year before Mr. Justice Cobb, where he ruled against the local authority. So that is the general tenor of the case law and the test to be applied when this issue comes up. And if I come back to summarize it, just to take it back to the absolute base for a moment, what it is this. Local authorities have always and will continue to, in the spirit of the Children Act, look to wider family members that can be assessed. And there is nothing wrong with that. That is entirely the right approach. However, there is no formal duty to assess, which means that whenever someone objects, a mother or father or someone else, to someone being notified by being told there's a child in proceedings, we need to assess, or would you like to be assessed? Whenever someone objects to that, it must be taken seriously. I think what you have to do, and this is how I would say to lawyers to advise social care on the ground, is you should try to discuss with that person what it is their concerns are and see if there's a middle ground, because we all know that there may be cases where mother says, I don't want my wider family to know because I don't want them to know that I was misusing drugs. Well, we don't have to necessarily tell them that at the start and to get an indication of who may be available to assess, so we can work around that and try to find a compromise. That's different to, I absolutely don't want them to know. And mother may agree, actually, as long as you don't share all of the information or you're limited and you only share X, Y, and Z, please explore the family. Whereas mother may take a hard stance of, no, I don't want them to know for X, Y, and Z reason. If a compromise then can't be reached in the discussions had on the ground, then the actual thing to do is to take it to court, to make a formal application, to have the court decide what should happen. And I've had this issue where some people have said to me, well, shouldn't mother take it to court? Shouldn't we just go ahead and do what we always do, which is explore the wider family? And if mother has an objection, she takes it to court. Sadly, no. And that brings us on to point 2, which is the procedure to be applied. What the procedure basically says is this, and rather this is what my suggestion is. We check with the parent first. So I'm going to speak to so-and-so, or can I have their contact details, have your mum's contact details or your grandma, or is there anyone else who wishes to be, who you think maybe wish to be assessed? I'll explore that. Parent goes, no, I don't want you to explore that. So you get to the bottom of it, you try and reach a compromise, you try and work out a middle ground. If that objection is maintained, one may say, well, shouldn't the parent apply? And no, the answer is the case law very much puts it in this way. If the local authority is aware that a parent objects to you approaching a family member and there is an impasse, so there can't be a middle agreement reached, then the local authority should make the application to the court to have the issue determined. Now, that doesn't necessarily mean that the authority is going to say, yes, we definitely should approach. It means that when it then gets to court, the court will look at that decision of ABC, apply the factors in ABC and make a decision. And it might be, as we did in my case before Mrs. Justice Cobb, we made the application primarily to just have a determination so that we could know, do we go down that path or don't we? Because we just don't know. And this is a case where nothing else will do, and plan of adoption may be the end plan. The last thing we want to do is leave it to the end, and then the whole thing gets scuppered because we have to do further assessments. So in that case, we made sure we did apply, we did take it to the court, and Mr. Justice Cobb dealt with the issue primarily to get a ruling. Now, when we got there, when we got before Mr. Justice Cobb, we did, in fact, when we applied the factors, took the view that the family members should be approached. So that was the argument I put up. Mr. Justice Cobb decided against it. I don't think within the authority we necessarily were so disheartened that he went against us. I think it was more, we're grateful to have a ruling so we know what to do in planning for the child. And so that is what I would say you need to do. If the objection is maintained, you apply so that the issue can be determined. So you could have a parent apply, but as I said, if you know they're objecting, you should make the application. And I think that's fairer, and it means that the authorities don't breach confidentiality issues, because either you have judicial sanction to do that or you don't. Now, confidentiality issues, let me just touch on that a moment again, because there's something I missed. When I spoke earlier, the social workers potentially trying to gather as much information as they can about this wider person without breaching confidentiality, there may be, in that, it's tricky, that one, because I recognize entirely there may be situations where they go, oh, we know that that part of the family or that person is known to, I'm going to pick a local authority, Barnet Social Care, and we want to get the information from Barnet Social Care, but would that breach confidentiality? Now, that's a tricky issue, because what is the answer to that? I would say, as the case law does, that when you look to how far social services should go to gather information as much as they can without notifying, without tipping them off, without breaching confidentiality, use the court to guide that. So when you make the application, there will be a case management hearing listed, and at that case management hearing, say to the court, we would like to gather further information on this person to know if they're realistic, so that we can properly address that limb of the test in ABC. We know this, this, and this. Should we approach this Barnet Social Care? Should we do this? Should we do that? And let the court guide you. Funnily enough, it's very careful stepping, and I entirely appreciate that, but that's what the case law suggests that you should do. So if there's any doubt about should we do it, should we not, let the court guide on the issue. And that way the authorities are always safe, because they don't breach confidentiality and there aren't some issues of human rights claims arising. So then let's look at the procedure. If you get to that stage where an impasse is reached, an application has to be made, mum hasn't made it, so you have to make it. What is the procedure for doing so? And to be fair to ABC, again, it's spelled out in quite a lot of detail what the procedure would be. So where the mother, let's look at number 3, the procedure, the relevant application to make. Where the mother requests confidentiality, it will need to decide at a very early stage whether an application to court should be made to determine whether or not the putative father or relative should be informed and consulted. There will be cases where, applying the principles summarised in judgment, the local authority can be very clear that no application is required, and planning for placement on the basis of the mother's consent can proceed. But in any case that is less clear-cut, an application should be issued so the problems concerning the lack of information do not arise when adoption proceedings are later issued. I think we've discussed that already about delay. In relation to the putative father, that application will be under Part 19 unless issues of significant harm have been made it necessary to issue proceedings for care proceedings. So let me talk to you about that. The application is under Part 19 if you're not in care proceedings. So if it's a pre-proceedings kind of application. But if in fact you are already in care proceedings, then you do it under Part 18. And I think I do put later, yes I do, use Part 18 if you're in the middle of live care proceedings. Let's talk about that then. When an application is made, the first thing the court will do is, of course, identify a judge. It has to be heard. It's a High Court application. So when you make the application, make sure you mark it as a High Court application. Please can it go up to the DFJ of our particular region, because it will need to be dealt with in the High Court. Then they will speak to the liaison judge and decide either they're doing it as Section 9 or they send it up to the High Court judge. Then the next thing that we'll have to do is identify parties. And technically, you don't have to name parties or respondents on the application. But of course, if you know the mother is objecting and she would be a respondent, then add her on, add the child on. Especially if you're in the middle of proceedings, you already know who the parties are. Do not notify the person whom the objection is against. So if the mother is objecting for father not to have the information, don't notify father. The court will then list a case management hearing, at which point it will include directions. And the kind of thing that you will want to set out to the court at that stage is, look, we'll need a statement from the objector, so mom spelling out why she objects and what she knows about that particular person, so say dad. We'll need, we can as a local authority make X, Y, and Z inquiry without breaching confidentiality, or we can put that information before you in the form of a narrative statement from the social worker, or we can make X, Y, and Z inquiry. There may be ABC, but we're not sure what to do, and the court will guide you at the case management hearing. And then timetable and skeleton arguments on the issue, applying that checklist or those factors from ABC, say, I don't know, 3-4 days before the hearing, and decide, are you going to have the hearing on submissions or evidence? I think it would be rare to have this kind of issue on evidence, and it really depends on what the mother says and whether certain things need to be explored on the back of what she's put in her statement, A, in relation to her objection, and B, in relation to what is known of that particular family member or a connected person that's being objected to. Chances are you will deal with it on submissions, and then you list a hearing on submissions to deal with it. So that's procedure, and I hope that helps everyone to understand that. And then if we bring it back then, big question, does the local authority have a duty to assess family members? The answer is no, but of course, the spirit of the checklist of the Children Act and the Adoption of Children Act is you must explore the wider family. If the objection comes up, try to resolve it with the mother. If you can't, it's part 18. If it is in the middle of proceedings, it's part 19 if it is not, and it's an application to the High Court where you will have to apply the factors in ABC of 2020 to reach a decision on the matter. It is not a case where the child's welfare is the court's paramount consideration. Now, I hope that's helpful. That's from me, and now Francesca is going to run through these cases we've discussed, A, B, C, H, and the one I was in, F, to give you some further detail and should help you to understand in practice how this works, or what decisions the court makes when these matters come before the court.
So the first case as an example is Re-H Care and Adoption Assessment of Wider Family, which Reagan's already mentioned. And essentially in this case, it concerned H, who was aged 5 months. He was the third child of these parents. They had 2 older siblings, which had already been placed for adoption, and a number of his half-maternal siblings had already been placed for adoption as well. The parents wanted to be assessed as carers for the child, but the assessment was indicated to be negative, as both had a long history of substance misuse and alcohol abuse. The maternal family were aware of the baby's existence, but did not wish to be assessed as carers. But the wider paternal family were not aware of the child's existence, nor that of his 2 older siblings. The father made clear he was very opposed to the local authority notifying his family about the child's existence, and in fact said he would prefer for the child to be placed for adoption than his parents to find out. The local authority wished to notify the paternal family to establish whether or not they were in a position to care for the child, and the children's guardian supported this position. The local authority's application was granted, but with the caveat that the father would have the opportunity to inform his parents himself first of the existence of H. The reasons for the decision were threefold. None of the provisions of statute, regulation or rules impose any absolute duty on either the local authority or children's guardian or the court to inform, consult extended family about the existence of a child. But the ethos of the Children Act is supportive of a wider family involvement in the child's life, unless that's inconsistent with their welfare. Secondly, this particular case was not a situation where Article 8 was engaged, because the paternal family had not met the child and therefore had not had the chance to build a relationship with him and have rights in terms of family life. And finally, there was no clear guidance, the court found, on this particular issue in the case law. So in light of those reasons, the court considered that the local authority can exercise broad judgment and discretion on the facts of each individual case, attaching primacy to the welfare of the subject child. although, as Reagan's pointed out, that welfare primacy principle was later undone by the next case that we'll look at, which is A, B and C, adoption, notification of fathers and relatives. This case concerned 3 children where each of the mothers had concealed the pregnancies from fathers and wider relatives. The question again was whether the local authority should notify the fathers before the plans were affected, as 2 had been decided that were going to be adopted and a 3rd had adoption as an option. In this case, it was held the relevant factors to consider are as follows: parental responsibility and whether the person that the mother wishes not to be notified has such, the Article 8 rights of the father or wider family, the substance of the relationships, the likelihood of the family placement being a realistic alternative to adoption, the physical, psychological or social impacts on the mother or others of notification being given, cultural and religious factors, availability and durability of the confidential information, i.e. when a mother might decline to identify a father and therefore there is no way of him being identified, the impact of delay and any other relevant matters. In this case, the court concluded that the maintenance of confidentiality is exceptional and often the balance of fairness will fall towards the party being notified, but the decision must be made by striking a fair balance between the factors present in that individual case. So it's very much fact specific. The final case, which Reagan was involved in earlier this year, is Re-F, assessment of birth family. This case concerned F, aged 15 months. F had regular contact with her mother and maternal grandparents, and the local authority sought to return F to the care of her mother in a highly supported community setting. The mother herself was adopted when she was aged 6, and the mother reported that her adoptive placement broke down when she was aged 13, as she contacted her birth mother via social media and subsequently got in contact with her birth mother and wider family members. F was born in January 2020, and 2 months later, the mother took her to see the birth family, during which F sustained a fractured skull. In this case, the court concluded that the local authority was under no obligation and indeed should not embark on any assessment of the wider birth family, not the adoptive family. It was held that the mother's birth family were her original family, but not her current family, and so nor were they her relatives. Furthermore, the birth family's limited contact with F fell so far short of supporting any finding that they required Article 8 rights to a family life with F, as it could not be established on purely biological kinship alone. Additionally, even if the birth family were considered to be brought into the definition of family, there would have been no obligation whatsoever for the local authority to inform, consult or assess them. It was also held that in this particular case on the facts, there were very clear reasons to steer away from the birth family as a realistic option to care for F, including the fact of the mother's own adoption due to neglect, the events surrounding F's injury in March 2020, and the accepted fact that the mother and her birth family had a very difficult relationship, particularly with the view of the professionals in that case, concluding that the mother should avoid contact with the birth family herself. Therefore, the court concluded that whilst there might be a situation where notification of a birth family could properly fall to be assessed, that wasn't the case on those specific facts.
Thank you, Francesca. So those are sort of like the 3, what's the word I'm looking for, most recent decisions on the matter. And I think they give a flavour of how this checklist, the factors and how the court will look at these matters generally will all apply on the ground. Thank you for listening. Has anyone got any questions for us? No questions. So either we've been sat here and no one's heard us for 45 minutes because the video link hasn't been working. And I really hope it's not that. So if someone could say, no, we get it, and we just don't have any questions, that would be great. Let's check. Has anyone said anything? Nothing. No question. Thank you, Catherine. Phew, I thought for a minute we hadn't been listened to. Everyone's just looking at us, moving our mouths. That's really great. I'm glad. Thank you, Lynn. That's really helpful. Thank you, Leanne. So if you guys have any questions that come up later on, I'm just going to stick my email address again in the chat. Remember, if you haven't had the handout, this is the email address you use to get the handout. And I hope that that was clear, that was helpful. And if it comes up in any of your cases, you should now know A, the legal test to be applied, but B, the procedure of what you need to do on the ground. There you go, there's my email address. And on that basis, you can all go away and have a lovely afternoon, and thank you for coming. Thank you, guys.